Hello, everyone, and welcome to this month's webinar, Workplace Policies 2025. What's new, what's changing, and what's next? This free webinar is available for all WorkWise Compliance customers. I'm Dan Helfrich. I'm the Senior HR Manager here at WorkWise Compliance. And in today's webinar, we'll discuss the crucial policies and procedures that employers should provide in their employee handbooks. We'll look at some best practices and also what should not be included. We'll also briefly discuss recent legislative updates that might affect your workplace policies. So today we'll explore the following topics: the overall purpose of an employee handbook and why you need one, current federal and state laws that dictate handbook content, proper implementation, suggested additional sections, what not to include, and updating and storing materials. In the final moments of our webinar, our guest speaker will answer some questions live, allowing WorkWise Compliance customers, such as yourselves, to engage with an HR expert on critical issues. Our speaker will also offer key takeaways from today's session while we engage the audience with poll questions. So, without further ado, I'd like to welcome Dr. Carrie Nelson as our featured guest speaker. Carrie's an independent HR consultant with 25 years of experience. She enjoys and is passionate about providing fractional HR support to clients across the globe. This includes policy development, including handbooks, guidance for employee relations and performance management, and much more. Before starting her consulting firm, Anova Resources, Carrie worked as a director and VP of HR in both for-profit and nonprofit settings. She also served as a board member for the Cambridge Women's Center in Boston and the Humane Society. Carrie has a BA in Business and Psychology, a Master's in Organizational Development, and a PhD in Industrial Organizational Psychology.
Thank you for that introduction, Dan. I'm pleased to be here today. In my current role, I work with dozens of business owners and other human resource professionals focusing on compliance with the laws and employee retention and morale. For most of my clients, I review and update their employee handbook and all their HR and payroll policies annually to ensure full legal compliance. The most important takeaway from everything we will discuss today is that it is highly advisable and will save employers money in the long run if each workplace reviews its existing policies on an annual basis. Along the same lines, I hope employers will learn about other policies they may want to add to avoid possible fines and penalties due to noncompliance.
Thank you, Carrie. And before we proceed, we want to ensure everyone can hear and see Carrie clearly. If you have any audio issues, please check the volume on your computer or mobile device. If that doesn't solve the problem, please let us know in the chat and we'll work to improve it as best we can. And with that, let's go ahead and ask our first poll question. Today's webinar is heavily dependent on audience participation. So to ensure that we're prepared to fill today's hour with helpful content, we need to know, what are you most interested in hearing about today? How to properly implement and distribute a handbook, the current federal and state laws that require specific policy language, what policies might be beneficial to your organization, and what not to include in an employee handbook. Please select all that apply. We'll give you a few more moments to answer. If you're having issues viewing the poll question, please try changing the camera layout on your screen. To do this, click the Active Camera drop-down menu and select the left camera position icon. I'm going to say that again because I went a little fast. If you're having issues viewing the poll questions, please try changing the camera layout on your screen. To do this, click the Active Camera drop-down menu and select the left camera position icon. All right, and based on the results, we have a lot of interest in current federal and state laws that require specific policies, and also quite a bit of interest in what not to include in an employee handbook. So thank you so much to everyone who responded. So this webinar aims to provide accurate and authoritative information on the subject matter being discussed. It does not constitute legal advice. Depending on your state, type of business, and number of employees, the tips and laws discussed today may require you to take specific action. We recommend working directly with your legal counsel and your HR professionals on matters pertaining to your business. WorkWise Compliance, the webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law or advice that could lead to unfavorable outcomes. Also, for attending this webinar session, WorkWise Compliance is offering attendees our 2025 HR Record Retention Guide, along with today's slide presentation equipped for note-taking. These resources are available in the Materials section of GoToWebinar. And at the end of today's session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I want to invite everyone to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. Questions will be saved for the end of today's session and may be slightly modified before presented. With that, Carrie, what's the purpose of an employee handbook?
Great, perfect way to get started. An employee handbook or a team member handbook, if you have 1099 contractors or other staff who aren't necessarily employees, contains information about a company's HR and payroll policies. The primary purpose is threefold. Number one, employers are legally required to inform employees about their rights, such as EEO protections and workers' comp benefits. Number two, it's important for employees to be aware of any responsibilities they have as part of their position. These responsibilities can range from the company's dress code to how to submit a timesheet. And three, it's a good idea to provide broad information about the company so everyone understands your history and your core mission.
Awesome. I think it's important that you mentioned employee rights, Carrie. Not only are company policies and procedures a compliance thing, but they also keep employees aware of their rights. Let's ask another poll question. So does your company currently have an employee handbook in place? Yes, and we regularly review it. Yes, but it needs a review and update. No, we currently do not have a functioning handbook. Please select the answer that best applies to your organization. All right, and it looks like most of you either have a handbook and it needs to be updated or it's updated pretty regularly. That is great. So Carrie, can you please review the guidelines to ensure that our attendees' handbooks are as up to date as possible? This can include federal and state-specific information.
Sure, Dan. Let's start at the federal level. First, I want to talk about the at-will employment. Nearly all handbooks should mention the concept of at-will employment at the beginning and the end. Every state except Montana allows employers to create an at-will policy. Let's think about a definition. At-will employment is an agreement that employment is for an indefinite period and may be terminated by the employer or the employee at any time. Now, what I just said was a definition, and you need to ensure a clear definition for this is in your handbook, not just that you are an at-will employer. Not everyone will understand what that means, or they might have different ideas about what it means. Make sure there's a clear definition. In fact, every topic should be clearly defined in the handbook. Let's talk about EEO next. As mentioned, the Equal Employment Opportunity Laws are one example of the employee rights that you are legally obligated to notify employees of. These regulations are enforced by the Equal Employment Opportunity Commission, or EEOC. The federal laws for EEO protections can be seen on the current slide, but we are also providing a link to that verbiage in the chat window. The words seen on this slide must be placed in every handbook. This is federal law applicable to every state. Additionally, every state where you conduct business may have additional protections that you need to review and add to your EEO policy. We will cover this later in the state-specific section.
Okay. And the handbook should also include information about reasonable accommodations and harassment and discrimination prevention, correct?
Yes, absolutely. Your employee handbook should include a reasonable accommodation policy that, in addition to offering reasonable accommodations for disabilities, might make accommodations for religious practices and sincerely held religious beliefs. You must remember, however, that creating a policy about something like the Americans with Disabilities Act, reasonable accommodation, is not enough. You have to clearly define the laws and inform employees of their rights. You must also explain what an employee can or should do if they have a question or a claim. This is also important when it comes to discrimination and harassment claims. Let's talk about that. If a situation involves discrimination or harassment, there are lengthy legal definitions for these terms: discrimination, harassment, and sexual harassment. It's important that your employee handbook and other relevant policies have the current legal definitions for these terms. Companies may implement stricter policies than the law requires, but the law should still be clearly stated.
And since this topic is so prevalent these days, what specifically do you suggest a discrimination and harassment policy contain?
So the discrimination and harassment policy should contain, like I said, the law and legal protections under the law, the importance of proper conduct, to be proactive, what's right and wrong, the process for reporting the claim, whether it's yourself who's experiencing it or others, an overview of the investigation process, and a clear definition of retaliation. Retaliation is any adverse action taken against an employee for filing a claim or participating in an investigation as a witness. No one can be retaliated against for making claims of harassment or discrimination.
Thanks, Carrie. What other federally dictated policies and procedures should be included?
Let's move on to the immigration and citizenship issues and employee classifications. All employers are legally required to verify employment eligibility before putting a new employee on their payroll. In my experience, most employers do this and they ask new employees for their identification. However, most employers do not have a written policy about this, and they should. Since this written policy is often missing, it is one of the areas where employers are fined most often. The Immigration Reform and Control Act became law in 1986. It's not new. It states that employers cannot hire a W-2 employee without verifying their identity and authorizing their ability to work in the United States using either a Form I-9 or the E-Verify system, which is required by some businesses and some states. This process includes inspecting the authenticity of their identification. So someone at your company is looking at their ID, looking at the person, and verifying it's them. Employers must reference this law in both their offer letters and the employee handbook. This is important because a new employee must verify their identity within 3 business days after the first day of employment. If they cannot give you the required identification, you must end their employment until they can provide it. This is enforced by Homeland Security. If you do not manage this process properly, or if you have any forms with missing information, you can be fined per page for non-compliance. It's a similar issue with employment classifications. This is another big topic that should appear in your handbook. So when I say employment classifications, I'm talking about conveying to others how each job description at your company is classified. Part of this includes, how do you classify an employee versus a contractor? Or how do you classify a full-time job versus a part-time job or a temporary job? Under employee designation, under the W-2 employees, each job description must also be classified as either exempt or non-exempt under the Fair Labor Standards Act, FLSA laws. This is critically important to explain because non-exempt job descriptions are eligible for overtime pay and exempt job descriptions are not. How you determine if a job description is exempt or not has to do with the duties involved and the salary range. It's important to classify each job description appropriately under the law because you can get fined for getting this wrong, especially if you do not pay an eligible employee overtime.
Thanks, Carrie. And from a personal standpoint, our handbook contains information about the FMLA, or Family and Medical Leave Act, but I know in some cases some of our attendees may not need to include that information. Can you go over those policy requirements?
Yes, that's a great point. On a federal basis, employers with 50 or more employees who all work within a 75-mile radius of each other must comply with the federal FMLA laws. These laws do not pay for the approved time off. However, it does require job-protected, unpaid time off, which is typically up to 12 weeks for those who qualify. Keep in mind, though, that most states have additional protections on top of these federal requirements, and each state varies in its rules. Whatever family and medical leave policies your company follows in each state where you do business should be included in your handbook, explaining workers' rights and protections, the process for asking questions, filing a claim, and the process for returning to work after an approved leave.
Excellent, Carrie. And before we move on, I'd like to encourage everyone in attendance to follow our blog for labor law news and updates that we post regularly. A link to our blog is now in the chat window. And let's go ahead and do another poll question to determine how much time we should spend on each of the following topics. Which of the following best describes your company's location? We're in one state, or we have office locations in multiple states, or my company is international with offices and workers in different countries. We'll give you a moment to answer. All right, it looks like a lot of our participants are in one or just a couple states, and then a couple are even in multiple countries. So thank you all so much for your responses. Carrie, how about we review some state-specific requirements for our audience?
Yeah, sounds good. Keep in mind that different states, counties, and municipalities have different laws that vary on the topics I'll be discussing. As just one example, the state of Illinois has a sick time law. However, if you're in Chicago, it's actually different. So we're going to go over this broadly. Business owners must understand the laws that apply and communicate them accordingly to their employees. So as a note, your primary state is where you are incorporated and may have the bulk of your employees. However, if you have employees working in another state, even if they're working from their homes, you must also comply with that state's laws. The following slides will discuss state laws that should be included in a handbook. The examples in this section are not a complete list of laws of every state, or we'd be here all day. It's recommended that you consult with your legal counsel or a human resource consultant like me to ensure that you provide all of the required information to your staff. So let's start with those state-specific EEO protections. The federal laws we already discussed and covered the basics, such as race and gender. However, each state has its own additional list of legally protected characteristics. And here are just a few examples of recent updates, recent changes. Illinois now added to their EEO decisions about reproductive health and family responsibilities. Maryland just recently added military status. Many states have that too. Virginia added ethnic origin. Race might be different than ethnic origin, so they wanted to put in that level of detail. And these are just a few examples. Some states have even added height and weight to their EEO protections. So it's not just bullying to make fun of someone because of their height and weight. It can actually be against the law. Many states also continue to pass the Crown Act, which protects employees' natural hair and hairstyles, including braids, afros, curls, and knots. This is a topic that should be in the EEO policies, but it might also be needed in your dress code. If you have any requirements about hairstyles and grooming, you want to review that in your handbook. Next, let's talk about meal and rest break policies because these vary significantly by state, type of employer, and employee position. These policies are typically enforced for non-exempt hourly staff. However, some states do not have any specific laws requiring these breaks. Here again are just a few examples of these state-specific break laws, which can get pretty complex. In Maine, Non-exempt employees who work at least 6 hours in their workday are entitled and expected to an unpaid off-duty 30-minute rest break unless there are fewer than 3 employees on duty at any one time and operations allow employees to take shorter breaks throughout the workday. And in that state, employees may waive their rest break in writing. Whew. In Nebraska, only certain employees are legally required to get a 30-minute meal break when working an 8-hour shift. Employees working in assembly plants, workshops, or a mechanical establishment who work at least 8 hours in their workday are entitled to a meal break of 30 consecutive minutes. To me, it's a very small group of employers. On the opposite side of the spectrum in California, it has many complex rules for both meals and rest breaks. In fact, they're so complex, I usually provide a chart, a detailed chart of if-then for my clients to make sure they're following the correct rule for the exact amount of hours each employee works. Another important rest break consideration is allowing new mothers to pump milk privately, which might require longer breaks or a different break schedule. This again is protected by law, and this could be placed in the employer's break policy or as part of an FMLA or a maternity leave policy.
Okay. And are there any tips you might have for employers regarding vacation policies?
Definitely. Most employers are not legally required to offer paid vacation time, but if they do, state laws vary based on how it is administered. For example, some states require employers to pay accrued vacation time when employment ends, while other states do not require it. Additionally, many states are also adopting paid sick time laws. For example, just a small example, Arizona, California, Colorado, Massachusetts, New Jersey, and now Missouri as just a few examples. In those states, most employees, including part-time staff, must accrue some portion of paid sick time. For states that adopted these paid sick time policies, the rules on how much is earned, if there's carryover at the end of the year, and if it is paid when employment ends, those rules vary. No matter the situation, the state required policy, you must know for every state where you conduct business, and it must be in your handbook. It's similar with the family and medical leave programs. They are the most complex and variable laws between the states. These programs might include paid or unpaid leave for an employee's own health or medical reason, leave to care for a family member, parenting leave, and even military leave for themselves or a family member. Some employees pay an additional tax through payroll for these benefits, and they get their claims through their state. It's important to be aware of all the leave laws in each state where you have an employee and communicate them properly. You are legally required to inform workers of these benefits. If you do not have a handbook, you are required to give multiple handouts during new employee orientations, and that can be pretty tedious. Handbooks, however, can have all of these policies in one place, and they can contain links to the appropriate state leave, break, and sick time laws, and everything else they need to be aware of. So now let's move on to the topic of domestic violence. It's a hot topic in employment law. Many states legally require employers to provide both time off and accommodations for employees who endure domestic violence issues. This information should be placed in your handbook. This is separate from the previously mentioned sections. In some situations, this policy can include paid time off under those individual sick time laws that I just mentioned. In other situations, it might be unpaid job protected leave. It's important that employers know the difference. Next, let's talk about whistleblower protection laws. These protect employees from retaliation or harassment for filing internal or external claims of possible company violations. The specifics of these laws vary by state also, but generally, covered businesses are required to create a whistleblower policy and include that in the handbook too. Another important set of laws that keep evolving pertains to jury duty and witness leave. Various states have unpaid job protections, and some even require employers to offer paid time off in these situations for jury duty and witness leave. Some companies on their own, without the government's requirement, they offer jury duty, paid time off for jury duty or witness duty. No matter what you do, all this information needs to be made available to your employees. Make sure they're all receiving the same benefits equally. On the same lines as voting. So most states offer unpaid job protected leave for voting. However, this becomes more of a concern for people with long work shifts. Most people can vote before or after work, but if someone's assigned to a 12-hour shift on voting day and they can't leave, you might need to accommodate them on voting day and allow them to vote, which again would be under the law. Workers' comp is another very important topic that is legally required to be provided to most W-2 employees. State laws vary as to when an employer must purchase workers' comp insurance. Some employers do not need to purchase it until they have 3 or 4 employees on payroll, but still affected employees must understand their eligibility and reporting requirements. All of this information also needs to be in the handbook. And finally, some states legally require employers to allow employees to access and photocopy records from their official human resource file. Before adding this information to the handbook, employers need to know what is required by them and what's required by the law, what can be stored and what can be shared. Employers should only save information in the official human resource file that the employee has seen before, so there's no surprises.
Thanks for that overview, Carrie. I want to take a moment to remind attendees that just as Carrie is here to help you and your company's policies comply with federal and state laws, WorkWise Compliance is here to help with workplace poster compliance. If you have any questions about the posters you need or your subscription level, please get in touch with a compliance specialist today. The number is now available in the chat window. For questions related directly to policies and procedures, Carrie can be contacted through her LinkedIn, and that address is also in the chat window now. Carrie, what other suggestions for policies and procedures do you suggest employers include in a handbook?
Yes, even though the following policies are not technically required by law, I do think they're helpful in company operations. So the following sections and policies could be included in the handbook to just inform employees of the company's culture. Number 1, a personal welcome statement to the employees. This sets the tone for the handbook. Your opening of the handbook should say, "Welcome to the company. I'm so pleased you're here. Thank you. You're so valuable to us." And that sets a nice tone for them wanting to read the rest of the handbook. An overview of the company's history, mission, vision, and values. This is useful to both new employees and also to existing long-term employees as a refresher. A code of conduct is a good idea, explaining what is and is not expected in terms of employee conduct and behavior. An introductory period statement is also good to have, dictating a specific time period when a new employee is considered in training. It's usually about 90-day introductory period. This used to be referred to as a probationary period, but the proper term now is introductory. You should also have a definition of conflict of interest, a whole policy built around this, especially when it involves employees dealing with a competitor or another job. If they have a secondary job, how should that be treated? It's always a good idea to have a dress code or uniform policy also. I sometimes get clients who think they don't need a dress code, and I say, well, what if you have an employee show up to the office or to a Zoom meeting with a swear word across their shirt? That would be inappropriate, and it's a lot easier to enforce rules when you have a written policy. They have to go and change. It's not acceptable, and you have the right to have a policy like that, as long as it's not discriminatory. And also, it's important to have a computer, email, or IT policy discussing the ownership of work email accounts, electronic equipment, and voicemail services. And there should be no expectation of employee privacy, which means, again, employers can access those documents, and you should make them aware of that. Other company culture-related policies that you might want to add include a company social media policy, a remote work policy. You have employees working remotely. If you're having issues, create a remote work policy. A grievance policy that goes over the internal process for stating employee concerns. What do they do if they have a complaint or an issue? It's a good idea to create a formal process so they know what to do and complain internally versus externally. You might also want to have an expense report and mileage policy. How do they get paid for those things? And a gift policy that clearly sets expectations for what gifts employees can and cannot accept.
Excellent. So two topics I think that have come up in past webinars are payroll and attendance issues. Would you recommend that employers include information about those topics in handbook?
Yes, those are two essential items to include. So I suggest, think of these sections and hours of work, core hours, timekeeping, and payroll policy. So the basics are, do I have to fill out a timesheet? When's the timesheet due? And when do I get paid? If you're getting a lot of questions like that, you might think, I should develop my policy further, put in more details. Brand new person coming in isn't going to know these things. Be proactive. Along the same lines, an attendance policy discussing what is considered being on time, what's being late, and how to report an absence. Every company is different about this. Are they supposed to call someone, text someone? Is it their supervisor? Is it someone else? Make sure your attendance policy is very clear. And a holiday policy that includes when the office is closed and if they are paid or unpaid for that time off. Another important section is performance evaluations. I think it's being transparent about your company's performance and termination policies is very important. So you might want to start with your performance evaluation policy. If you have a consistent performance evaluation system, like every June you do performance evaluations, put that in your handbook, tell people up front. You might even want to give them that form when they start so they know what they're going to be graded on. A summary of your company's progressive discipline policy, if that exists. You should have progressive discipline. If there's a minor performance issue, it should be verbal warning, written warning. And yes, you can skip your steps if you need to based on the situation and you write that in there, but have a general discipline policy. Again, employees won't be as surprised if they're getting a written warning if they've seen the policy in the handbook. And also an employment separation policy that might include guidelines for giving notice. How should they give notice, returning company equipment, and your exit interview process.
And Carrie, which workplace safety related policies do you recommend including in a handbook?
Yes, so as a final step in reviewing the policies in the handbook, I think it's always good to acknowledge the company's commitment to workplace safety. Again, this varies by company, but it can include the company's commitment to safety statement, something proactive that explains to employees how to report any safety violations they may see. You might also have a smoke-free workplace policy, always a good idea, and a drug and alcohol-free workplace policy. Keep in mind that any pre-employment, random, or reasonable suspicion drug testing policies you have should also be included.
That's great information for employers to remember. I do want to ask though, how can an employer prove that an employee knew about a policy but still disregarded it?
That's another excellent question, Dan. And it leads us to what I think is the most critical part of an employee handbook, the acknowledgement form. The employee handbook acknowledgement form is a page that the employee signs and returns, or if they complete online with an electronic signature. That form should state that the employee received the handbook and they understand they are responsible for reading it, adhering to the policies and procedures, and letting their supervisor or management team know if they have any questions. If new handbooks are issued to existing staff, another item that is important to include on the receipt page is the date of the updated version. It's also a good idea to include page numbers throughout the handbook and the date of the latest handbook on every page.
Thanks, Carrie. And as a thank you for attending this webinar, all of our viewers can download WorkWise Compliance's attorney-reviewed employee handbook and acknowledgement form, which can be used in these types of situations. The form can be found within the Materials section in GoToWebinar. Now let's go over what policies and information should not be included in an employee handbook.
Absolutely. It can be very easy to get carried away when creating or updating a handbook. You want to get it all done, you want to get it all in there, have all the knowledge in one place. However, I stated at the beginning of the webinar, an employee handbook should contain information related to a company's HR and payroll policies. It should not include information like job descriptions or operational procedures, how to complete a task. Salary information, including any future mention of raises or bonuses. You don't need to make promises like that. Elective benefits, which is often in handbooks and I remove, such as medical and dental insurance. If you're putting in, our medicals with Blue Cross and employees get it for free, you could be painting yourself in a corner because that might change when you have your next open enrollment for benefits. Another thing that shouldn't be included in handbooks are specific employee names, since individuals could leave the company, but you can use job titles instead. Why is this important? Because if you put these things in your handbook and it changes, then you need to issue new handbooks and get everyone's signatures again. That can be time consuming, and you ideally want to issue a new handbook once a year.
Okay. And is there a rule that employers should follow as to when they should implement their company's employee handbook?
Yeah, so my easy answer is that employers should have created their very first employee handbook, including company policies and procedures, when their very first W-2 employee is hired. I do know, however, that some companies have waited until they have a certain number of employees before building their first handbooks. Some companies, no matter how long they've been established, still don't have an employee handbook. My answer to those businesses is to build their handbooks now. Not informing employees about their rights and responsibilities puts the company in jeopardy of lawsuits and governmental fines.
Thanks for clearing that up, Carrie. What should the process be when updating the policies within a handbook?
Well, once you have an existing handbook, I think it's a good idea to assign someone internally to keep a draft copy and update any changes to internal policies throughout the year. For example, if you have a slight change to your dress code policy or the process for expense reports and who they go to, goes to the office manager instead of the VP of Ops, keep a running list of small things like that. Ideally, you as the employer would be responsible for having your company specific policies updated. Then, once a year, have an HR consultant or lawyer review the applicable HR laws in your states and create a new handbook to be released. If they're good at their job, that consultant will also monitor your state laws throughout the year and inform you if there are any major changes. Then, when you do release a new handbook, I recommend the following best practices. 1, announce the approved update to all employees via email or in writing some way. If this is an update to an existing handbook, make a list summarizing what was changed so they're properly informed. You don't want them to read the old handbook and the new handbook side by side, line by line to see what was changed. Make it easy, keep a list as you're updating it. Then after you announce it in writing, a few days later, conduct a company-wide meeting in person or online, highlighting the important policies, rights, and responsibilities included in the new handbook, and allow a Q&A session for employees to ask questions and provide feedback. I help facilitate this for some of my clients, and sometimes we're surprised by the feedback and questions. 3, I also recommend that you have a second meeting with managers to explain what they can do to enforce the new or updated policies. Think of it like a manager training. It's just once a year. Are they having any problems in managing things like attendance policy or the dress code? And are they enforcing the same rules and policies equitably between their teams? And then number 4, if possible, release the handbook through a payroll system, internal portal, or other digital means to allow for electronic signatures, acknowledgements. Many of my clients are surprised to learn that most payroll systems allow you to do that for free, and it saves a lot of time. You should set clear guidelines for signatures to be obtained. It is a condition of employment to sign the receipt of the handbook. Signing does not mean that they have read it all or even if they agree to every single policy. It's just an acknowledgement of receipt.
Awesome. And one cool thing through my payroll software, you can make it so that every new employee has to sign it also. So I really like
Yes.
putting it through the payroll system. But you just mentioned the acknowledgement form signatures. What record keeping rules should the audience know about?
Yes, again, good point. Each signed employee acknowledgement form must be stored and saved, whether they were received digitally, online or physically. If a handbook was updated and distributed multiple times, each round of forms should be dated to correspond with the date of the employee handbook's release and stored together with the employee file. Do not dispose of previous versions. of the handbook signature. You want them all. There are many reasons why proper record keeping of the acknowledgement form is needed, the least of which may be to clarify rules or to reiterate performance coaching. Like, hey, we changed the policy about shorts last year, and here's your signature after we sent that handbook, to clarify. Another reason for record keeping is to challenge possible unemployment and other legal claims. A terminated employee may claim they were unaware that what they did was a fireable offense. However, a signed acknowledgement form could prove otherwise.
Thanks, Carrie. Over the recent months, there's been a lot of movement in the federal government when it comes to the signing of numerous presidential executive orders and the restructuring of federal government agencies. For example, the National Labor Relations Board, or NLRB, rescinded multiple enforcement memos issued by previous administrations. Do any of these updates currently affect workplace policies?
I know a lot of human resource professionals are keeping a close eye on the different executive orders coming out from the White House. But for now, the good news is that the orders do not affect the policies we've discussed today. The EEO laws that employers are required to follow dictate that employment decisions must be made without regard to personal protected characteristics such as age, race, gender identity. What President Trump's new executive orders focus on are diversity, equity, and inclusion, DEI programs within federal agencies, which could be seen as discriminatory. Similar items such as affirmative action plans that government contractors were required to create and enforce in the past are also discussed in the executive orders. Depending on the department and structure, some of those affirmative action plans gave preferential treatment to people with certain characteristics. That practice under the current executive orders is now deemed unfair. For private employers, no change to the Title VII of the Civil Rights Act or the EEO laws were made. So you mentioned the NLRB. It's important to recognize that the primary purpose of the National Labor Relations Act is to protect the rights of private sector workers who might want to organize and bargain collectively in a union. The NLRB has historically balanced the weight of employees' rights against the employer's rights to establish work rules and maintain discipline, especially in current unionized environments, or for any non-managerial group of employees who may want to form a union. In those situations, they're protected. So what does that mean? For example, an employer cannot stop their employees from meeting during their breaks or other non-work time to discuss, form, or promote a union. Most employers also cannot stop an employee from wearing a pin or jewelry that displays a union logo, even if it violates the dress code policy. In fact, in those situations, you would actually have to change your dress code policy in accordance with the NLRB laws. The recent rescinding of some agency memos could signal a change in future NLRB enforcement. However, at this time, updated guidance has not been released. Therefore, company policies and procedures don't need to be changed.
So there are some other topics that received a lot of news over the past year or so. Those include the use of non-compete agreements, AI technology, and employee tracking and monitoring tools. Are those subjects that should have distinct policies within the handbook?
Well, to begin with, I don't believe that these topics that you just mentioned belong in the employee handbook. They can, however, be addressed as separate specific agreements. When it comes to non-compete agreements, for example, the Federal Trade Commission recently proposed a nationwide rule that would ban them entirely. That rule, though, was overturned. So non-competes were not banned on a federal basis. However, some states do ban non-compete agreements, and companies should know if they are affected by those laws and change their policies accordingly. As for the other topics you mentioned, it's important to research those things thoroughly before creating any policies. For example, involving the use of AI or tracking technology to track your employees in the workplace. If you feel that you need or want these kinds of policies, again, I would not put them in the handbook, but instead supply them separately. And finally, since these are fairly new or constantly changing issues, I would strongly recommend that your legal counsel review those policies before they are distributed.
Thank you, Carrie, and thank you for talking with us today. I want to remind our audience that the 2025 HR Record Retention e-guide and Employee Handbook Acknowledgement Form are available as downloads in the materials section of GoToWebinar. So before we move into our live Q&A session, we have one last poll question we'd like to ask our audience. For future presentations, what would you be interested in hearing about? Best practices in creating and implementing an emergency action plan, or an EAP, how to maintain workplace privacy and proper cybersecurity, how to respond to workers' compensation claims, or I'm not interested in any of those topics. Please select all that apply and we'll give everyone just another moment to answer. And it looks like we have a lot of people interested in an emergency action plan or how to respond to workers' comp claims. So we'll take that under advisement for future presentations. Thank you so much for your responses. So to participate in today's Q&A session, I encourage everyone to submit questions through the questions feature in GoToWebinar. We'll do our best to get through as many questions as possible, and all unanswered questions will be submitted to Carrie for responses and sent to you via email. Please note that after the Q&A portion, Carrie will provide her key takeaways from today's session. With that, let's look at our first question. All right, first question. Do we have to use the exact legal language in our policies when we reference things like EEO or other labor laws, or can we paraphrase? Good question.
Great question. Yes. So you can paraphrase, but it's only so that you can make sure your employees understand the law. You can't change what is written, but if they're using legalese that your employees do not understand, I don't understand some of the legalese and some of these new laws that come out. So if you're paraphrasing or putting more detail explaining what it is, that is okay. But again, you can't change. If you want to change anything or ask, it's okay. Check with a HR consultant or a lawyer just to make sure what you're saying doesn't violate the law. Good question.
Good answer. All right, next question. Our medical practice is located in Pennsylvania. We have one employee working in Delaware and one employee working in Georgia. Do we need to have a different handbook and or policies for those two out-of-state employees? Good question.
Yes. So you don't necessarily need to have a different handbook, but you should review the laws in those two other states. You know, you do have to register as a business as those states, make sure you have workers' comp for their homes. And if there's any laws in that state regarding sick time, all those things that I mentioned, voting leave, jury duty, family medical leave, you do need to make sure that those employees are aware of it. I find that multi-states, employers in multi-states, it's easier to just to have one handbook and to say, these are the sick time laws in Delaware, these are the sick time laws in Pennsylvania, something like that. I like it all together in one place. It's easier to administer. However, if you feel that there's one employee in a state, let's say, for example, I work in California, and maybe they get other benefits that you don't want to give to your other employees, you may want to have an addendum page that says just for that state, and you can create separate addendum pages just for them. Otherwise, I recommend that you just have one handbook because all the other policies will still apply to all of them.
Awesome. Yeah, my handbook has a couple addendums for a couple different states.
Mm-hmm.
Thank you for asking that question. That was excellent. All right, and question number 3. Earlier, you said that employers can be fined for not having certain policies in their handbook. However, when I Google if I'm legally required to have one, it says I'm not. How can I be fined if I don't legally have one?
Oh, well, it depends on the situation. You can be fined for violating the law. Let me clarify that. Let's say you don't pay someone overtime, you can be fined for that. And the best way to do that so that everyone knows is to put it in your handbook. So if you have a written policy, you're more likely to follow it, the employee is more likely to follow it, and their manager is more likely to follow it. So having that law protects you in that way.
Good answer. All right. Fourth question here is, what is the difference between a grievance policy and an open door policy? Should we include both?
That's a great one. So let's start with open door policy. It's great for companies to have an open door policy, especially if you have a lot of new employees or younger employees that have their first job. You might want to have an open door policy that explains they should feel free to ask any question or concern or present any idea to their manager or perhaps the management team. So it's great to put that in there. A grievance policy, though, is a specific policy that explains what to do if they're having a problem. And a lot of companies, I add this to a lot of handbooks. So it could be everything from I'm not able to wear shorts, but I see this person over there wearing shorts. I think I'm being discriminated against. What do I do? Who do I go to? And it can say step by step what is a grievance and who to go to. When to go to your manager, when to go to your manager's manager, when to go to HR if you have an HR person. So it's just a good idea to explain that step by step so that everyone is following the same process. Again, not just for your employees, but for your managers too. And so that grievances are addressed. You don't want to sweep them under the rug if it's a legitimate grievance or something that's possibly breaking the law. So you definitely want a step-by-step process so that internal people are informed. And then also it's important to have a closure process. Like sometimes something like the paint color on your wall, sometimes it's not really a grievance. It's not something we can fix. We heard you, but we've gone through step 3 and we're not making a change. The matter's now closed. If you have that in writing and a grievance policy, it helps navigate through all the grievances quickly.
Excellent. All right, and it looks like we've got time for 2 more questions here. So, what if a supervisor enforces a policy differently from how it's written in the handbook?
Good. Everyone's paying attention. I like that. Uh, if one manager is enforcing a policy different than other managers, you could potentially have a lawsuit. Let me just think of something. If you have someone in the same position in different states and they've come 5 minutes late and that manager fires them for being 5 minutes late, but there's another employee who's late all the time, maybe in another region, another department, whatever it is, and they get to stay, that person who was fired could try to sue for discrimination. They could say they were treated differently than someone else. And that's very important with your HR laws, no matter what it is, whether it's your attendance, timesheet, anything performance related, anything disciplinary related. It's really important that you have consistent rules and processes for those things. That's another reason why it's good to have an HR person or an HR consultant, where if any employee is getting a write-up, one person is reviewing all those write-ups to make sure there's consistency across the company. And if all the managers are giving 2 or 3 warnings to someone when they're 5 minutes late, 10 minutes late, and one manager wants to fire them, someone should stop them and say, no, our policy is to give them a written warning first, and I'm going to help walk you through the standard form we use for all employees. That's very important. Good question.
Yeah, consistency is key. And one more question here, I think we have time for. All right, should we include policies about AI tools even if we don't use them yet?
Well, no, I would say no. Why put in a policy that you don't have yet? But if you are planning to in the future, again, I wouldn't put that in the handbook because when you do implement them, I would announce that separately and say, this is what we're doing, this is how we're doing it, this is how to use the technology. If you're about to implement something soon, tell them way in advance, do a training, do reminders, all of that. You could put it in the handbook if it becomes an issue. I guess if it's, again, a performance issue of what to do and not to do, like a social media policy. But really don't load it up with things. Don't just fill it with every rule you can think of, because you want it to be the actual things they need to follow right now so they'll read it.
Good answer. Okay, and to be respectful of everyone's time, let's go ahead and stop there. All unanswered questions will be forwarded to Carrie, and her responses will be emailed to all attendees in the coming days. Thank you so much to everyone who submitted a question for today's session. Carrie, can you please leave us with some key takeaways from the information we discussed today?
Yes, so to summarize, there's a few things I'd like our audience to think about and remember from today's discussion. So 3 things, starting with when creating and updating the policies for your handbooks, include both the federal and state laws that may apply to your business. Please do not take another company's handbook from the internet. You might have completely different rules to follow in your states. And remember that the company's industry and size sometimes dictate what laws you might need to follow. At the same time, an office or work location can affect the laws that you must specifically comply with. So two, be sure that you only include company policies mainly pertaining to HR and payroll. It would be best to exclude anything that could change in the near future, such as elective benefits, job descriptions, pay scales, and any promises of raises or bonuses. And finally, number three, in order to have a really good handbook, consider putting a plan in place that assigns one individual the responsibility of tracking internal company policies to ensure those are communicated properly. And most importantly, make sure to have a full legal review of the laws at least annually.
All right, thank you for those takeaways, Carrie. And that concludes today's webinar. Thank you for attending our presentation. We hope you found the information helpful in assisting you in creating and maintaining policies and procedures for your workplace employee handbooks. Thanks again to Carrie for being our guest speaker. We look forward to continuing to work with you, Carrie, on future presentations. As a reminder, all viewers will receive a follow-up email with a certificate as proof of attendance, along with the recording of today's webinar. If you enjoyed today's session, we invite you to view past webinars on demand within our digital resource library. You can access checklists, forms, and training materials that address topics discussed in today's session. To register your account and access the library, click the link in the chat window. If you've already registered for the Digital Resource Library, click the second link in the chat window. That would be to log in. If you have any questions about the Digital Resource Library or WorkWise Compliance, please get in touch with one of our customer service representatives today. The phone number is currently in the chat window. To all of our attendees, thank you for choosing WorkWise as your provider of labor law compliance solutions. We'd like to ask you to please participate in the short survey that will become available at the end of today's session. Thanks again for attending, and I hope you have a great afternoon. Take care.